Welcome to another video in the TRESA series. The video series has been developed to help brokerages and real estate agents understand the key changes coming to the laws that regulate trading in real estate in Ontario. This video deals with the key change in the final set of regulation amendments that form part of Phase 2 changes taking effect December 1st, 2023. I will be discussing brokerage representation, designated representation, and multiple representation under both representation models. I will also be answering some of the most common questions about designated representation. Let's begin by reviewing brokerage representation and multiple representation under that model. For clarity, that is how representation must currently be practiced under REBA. Representation under REBA is always at the brokerage level. This means that all the brokerage's agents are bound by the same duties and obligations as the brokerage. They must promote and protect the best interests of the client. They owe an undivided loyalty to the client. When a brokerage engages in multiple representation, its loyalty to each of its clients involved in the trade can only be described as divided. It can no longer promote and protect the best interests of each of its clients in the trade or advocate for each client's respective interests in all aspects of the trade. It's important to note that any alteration of duties and obligations at the brokerage level applies to every agent employed by the brokerage. This means the brokerage and its agents must not offer advice on matters such as price or other terms that would be in only one of their client's best interests to include or to accept. The brokerage and its agents must not offer any advice to one client that is not in the best interests of the other client. The brokerage and all its agents must treat each client in an objective and impartial manner and not put the interests of one client ahead of the other. To be very clear, under brokerage representation, it does not matter if each client is working with a different agent employed by the brokerage or if the clients are all working with the same agent. The services and representation are limited in the same way. This should be understood by all registrants today. Let's consider a scenario. Lily and Theo work for the same brokerage. Lily is working with the seller and Theo is working with the buyer. Both clients are under brokerage representation agreements, the only type of representation currently permitted in Ontario. If Theo's buyer expresses an interest in the property of Lily's seller, the brokerage is now in multiple representation. When multiple representation is identified, Theo and Lily must immediately disclose the multiple representation and seek permission to continue. Let's assume both clients consent to multiple representation. Lily can't provide any advice about the price to accept. Theo can't provide any advice to the buyer about how much to offer or what terms to include in the offer. Lily and Theo can't provide any advice that might not be in the best interests of both clients. This is a risky situation for a client who is no longer benefiting from the expertise of their agent. It's also a risky situation for agents who are particularly inclined to be helpful. It can be very difficult not to provide advice or continue to advocate for the best interests of the client that you have been advising and advocating for up until the multiple representation arose, especially if they don't personally know the other agent. For the clients, their only alternative to multiple representation is to seek representation from a different brokerage. Remember, the agents must inform the clients of the multiple representation and cannot engage in multiple representation unless all the clients agree. It is the decision of the clients. Understanding and appreciating the challenges this presents for brokerages and agents, RICO pursued the introduction of designated representation, a form of representation that has been in place in other provinces for several years, as an option for brokerages who choose it. Now, let's talk about the introduction of designated representation. I will briefly explain designated representation, and then I will answer some of the most common questions about designated representation. Under designated representation, the representation agreement remains with the brokerage. The difference is that the agreement identifies an agent as the designated representative for the client. The designated representative is the agent that will provide representation to the client. Put another way, the designated representative is the agent responsible for promoting and protecting the best interests of that client, while the brokerage and all other agents remain objective and impartial. The designated representative is also responsible for protecting the confidential information of the client. This means confidential information, such as the client's motivation to buy or sell and their financial circumstances, must not be shared with any agent who is not a designated representative for the client. The brokerage and all other agents employed by the brokerage are not representing the client. The brokerage has specific responsibilities under designated representation. The brokerage must protect each client's confidential information. This includes ensuring that a designated representative does not disclose the client's confidential information to any other agent employed by the brokerage or other person, unless the client provides written consent or the disclosure is required by law. The brokerage must treat the interests of clients that have entered into designated representation agreements in an objective and impartial manner. It is the designated representative identified in the agreement that is responsible for promoting and protecting the best interests of the client. The brokerage is still responsible for supervising every designated representative to ensure they fulfill their duties under the designated representation agreement. And, in the event that a designated representative is not able to represent a client, the brokerage must designate a different agent employed by the brokerage to be designated representative for the client, if the client agrees to the new arrangement. Designated representation is distinctly different from brokerage representation, where the brokerage and all of its agents are representing the client under the brokerage representation agreement. Who receives and has access to confidential information is also an important distinction between the two types of representation. Let's begin with one of the most obvious questions about designated representation. Question 1. How does designated representation benefit clients and agents? The benefit of designated representation is obvious when a brokerage has more than one client in the same trade. As noted earlier, under brokerage representation, the brokerage and all its agents are no longer able to advocate for the client's interests. Under designated representation, the representation is different. Let's look at a simple scenario. Ethan and Matthew work for the same brokerage. Ethan is the designated agent for the seller. Matthew is the designated agent for the buyer. Matthew's buyer client expresses an interest in Ethan's client's property. Because each client is represented by a different designated representative, it is not multiple representation. That means there is no change to the services or representation that Ethan and Matthew can provide to their respective clients. Ethan and Matthew can continue to promote and protect the best interests of their respective clients in the trade. Ethan can advise his seller client on the price to accept, the terms to include in the APS, and any other matters. Matthew can continue to advocate for his buyer's interests, advising the buyer on the amount to offer and the terms to include in the offer. Designated representation significantly reduces the likelihood that a client will end up in multiple representation. Let's look at another scenario. Abby is holding an open house for his seller's property. A prospective buyer views the property and is interested in purchasing it. Abby asks the prospective buyer who their agent is, and the buyer tells Abby they don't have an agent yet. Under brokerage representation, Abby and the brokerage could not take on the buyer as a client because it would create a multiple representation situation, and this would not be in the best interests of the seller client. The only way the seller and prospective buyer could benefit from full representation would be if the buyer was represented by a different brokerage. Under designated representation, where Abby is the designated representative for the seller client, he could not take on the buyer for the same reasons, but he could refer the prospective buyer to Sylvie, another agent in the same brokerage. Abby knows Sylvie is very familiar with the area and will represent the buyer client well. Both clients continue to benefit from full representation. The risks associated with multiple representation are avoided. Question 2. Who decides if the client and brokerage enter a brokerage representation agreement or designated representation agreement? The agreements continue to be between the client and the brokerage. The brokerage will decide which type of representation it prefers to engage in, depending on multiple factors. Based on the experiences in other provinces, RICO anticipates most brokerages will shift to designated representation agreements to provide full representation, advocacy, and advice to clients in situations that would, under brokerage representation, be multiple representation. Some brokerages, where the sharing of confidential information between agents can't be avoided, or where it is the preferred way to operate, might choose to continue to use brokerage representation agreements. It is expected that virtually all brokerages will choose a single business model and not engage in both types of representation on a case-by-case basis, though some may have reason to practice both depending on the circumstances. This is a business decision that each brokerage will need to make. Question 3. Can a brokerage practice both forms of representation? While brokerages aren't legally prohibited from entering into both types of representation agreements, caution is advised. RICO expects that virtually all brokerages will choose a single business model and not engage in both types of representation on a case-by-case basis, though some may have reason to practice both depending on the circumstances. Remember, brokerage representation includes the brokerage and all its agents, which would make it unworkable to have one client in brokerage representation and another in designated representation in the same trade. Let's look at a scenario. Nathan and Marilyn work for the same brokerage. Nathan is the designated representative for the seller client. The brokerage and all other agents are not providing representation to the seller. Marilyn is not representing the seller because she is not a designated representative under the agreement. Marilyn is working with a buyer client under a brokerage representation agreement. The buyer is being represented by the brokerage and all its agents. This means Nathan is representing his seller client under the designated representation agreement and is also representing the buyer client under the brokerage representation agreement. In this scenario, if the buyer Marilyn is working with expresses an interest in the property offered for sale by the seller Nathan is representing, they are now in multiple representation. To effectively implement and benefit from designated representation, each of the brokerage's clients would need to be under designated representation agreements, which ought to be established from the outset. You can see from the scenario I just described the challenges that arise when a brokerage uses both types of representation agreements. A possible exception to this might be a situation where the brokerage decides to use designated representation agreements for its residential real estate clients and continues to use brokerage representation for its commercial real estate clients. Again, this is a business decision that the brokerage will need to make, and agents will need to confirm what their brokerage permits and to engage clients in one model or the other from the outset. Question 4. Does designated representation mean double-ending is banned? The short answer is no. If the required disclosure is made and each of the clients consent, a designated representative could have more than one client in a trade. Agents should make sure they are aware of and complying with any brokerage policies that are in place. While permitted by law, some brokerages prohibit their agents from acting for a seller and a buyer in the same trade to protect the brokerage and its agents from potential litigation. If your brokerage does permit double-ending, there are a few things to keep in mind. RICO understands that designated representatives may find themselves with more than one client in the same trade. For example, the agent is the designated representative for a buyer who expresses an interest in a property, and the agent is also the designated representative for the seller of the property. The agent is the designated representative for two different buyers who are both interested in the same property. These situations arise from time to time and are different than those involving prospective clients. A designated representative knowingly entering a client relationship that results in multiple representation assumes added risk, a risk that extends to the agent's brokerage. Even if proper disclosures are made and the necessary consents are obtained, the initial client might later consider the agent's actions to have been in conflict with the agent's duty of undivided loyalty and the agent's duty to act in the client's best interests. Taking on a new client, when the designated representative knows it will immediately result in a multiple representation situation, is not in the best interest of either client. The existing client should first be consulted, the circumstances explained, including how the representation and services will change, giving the client the opportunity to make an informed decision. The real estate agent's advice to both clients about the nature of the relationship and multiple representation could also come into question. The client's interests, not the agent's, must come first. Clients might believe they will save money by engaging in multiple representation. If disclosed properly, it should be clear to the client that they will no longer benefit from the advice and protection of their interests that they expect an agent to provide. The perceived savings may come with unforeseen consequences and costs for one or both of the clients. Question 5. Can there be more than one designated representative for a single client? Yes. In fact, there will be situations where it's necessary to designate more than one. For example, an agent has another agent working as an assistant, sometimes referred to in the industry as a licensed assistant. Confidential client information is regularly shared between the two agents. In this situation, the designated representative agreement should identify both agents as the designated representatives for the client. This would permit the sharing of information to continue. Another situation where this might be necessary is where registrants practice in teams. While teams aren't recognized under the legislation, the same rules would apply. All agents who might have access to or might discuss the client's confidential information should be identified as designated representatives under the agreement. Brokerages should consider policies to address these types of situations if they choose to engage in designated representation. Likewise, agents should ensure they are following any brokerage policies that are in place. Question 6. If I am the designated representative, who can take care of my client if I'm away on vacation or become ill? The brokerage, in consultation with the client, may designate another agent within the brokerage to act on the client's behalf for the period of time you are away or otherwise unavailable. The designated representation agreement would be amended accordingly. Alternatively, the designated representation agreement could name more than one designated representative at the time the agreement is entered into. Question 7. If I am the designated representative and I move to a different brokerage, does the client move with me? As I mentioned, the representation agreement is still with the brokerage. The agreement should include a clause that permits the brokerage to designate a new agent, subject to the client's approval, if the designated representative leaves the brokerage or ceases to be registered. Brokerages would be expected to have policies in place to address how to handle these circumstances. If the client does not want to work with a different designated representative, the designated representation agreement ends. There are also some questions specific to brokerages and brokers of record that I'll address next. Question 8. What does the brokerage need to do if it wants to transition to designated representation? There are some steps the brokerage will need to take. Brokerages will need to establish written policies and procedures related to information barriers that support the introduction of designated representation and other matters, such as whether or not a backup designated representative is identified in the agreement or addressed when required. Brokerages will need to make sure that all of their agents and other brokerage employees are using the right type of representation agreement, understand how confidential client information must be protected, and are aware of any other brokerage requirements related to designated representation. Where possible, brokerages who want to operate under designated representation should consider having their existing clients enter into designated representation agreements to avoid any confusion. For many brokerages, this will be easier than having to monitor which form of representation each client is under and in which circumstances multiple representation arises. Question 9. I'm a broker of record. One of our agents is the designated representative for the buyer and asks me for advice regarding the contents of the offer. Another one of our agents is the designated representative for the seller. What can I do to help the buyer's agent? As the broker of record, you must remain neutral. You must not give advice to the buyer's designated representative that may be detrimental to the seller client of the other designated representative. In this case, you could review the offer and provide advice that does not put the interests of the buyer ahead of the interests of the seller. If there are brokerage guidelines or policies related to the content of offers, you can refer the agent to those materials. The advice you're able to provide in this situation is similar to the advice you would be able to provide if the seller and buyer were under brokerage representation agreements and the brokerage was in multiple representation. Question 10. I'm a broker of record who also trades in real estate. What do I do if I am the designated representative for one of the parties to a trade and one of our agents is the designated representative for another party to the same trade? In this case, your role is to promote and protect the best interests of your client as their designated representative. As a result, the brokerage's responsibility for supervising the other designated representative to ensure they fulfill their duties would have to be assumed by another experienced agent in the brokerage. Brokerages may want to review their management structure and policies to ensure they can address these situations when they arise. Question 11. Does the brokerage still have access to client information? The brokerage still has access to the client's information with respect to the representation agreement and what is required for the brokerage record keeping. This will include the client's personal information. The information the brokerage must not have access to is the confidential client information, such as the client's motivation to buy or sell, the minimum amount a seller will accept, or the maximum amount a buyer can offer. The designated representative must not share this information with any agent or other person employed by the brokerage. Effective brokerage policies would help to protect a client's confidential information. We discussed multiple representation disclosures and consents in Part 2 of this video series. While there are some changes related to the specific content required, depending on the type of representation, the general rules remain the same. Details regarding the content of different multiple representation disclosures will be addressed in a bulletin on the topic. Brokerages must ensure that any disclosure forms developed by the brokerage or a third party comply with the general requirements related to disclosures, consents, and acknowledgments required under the legislation and the specific requirements related to multiple representation disclosures. In this video, we covered brokerage representation, designated representation, and multiple representation under both forms of representation. We encourage you to view other videos in the TRESA series. The videos in this series, bulletins, and other related information are available on RICO's website in the TRESA Explained section. Thank you for watching and for your continued commitment to professionalism.